Welcome to the debate. Today we are examining a truly exceptional feature of American constitutional law, the 21st Amendment. Now, most people remember it for repealing the 18th Amendment, ending the disastrous experiment of prohibition, but its structure is unique. It's the only amendment ever ratified by state conventions rather than state legislatures, which was a very deliberate procedural choice intended to maximize state control over intoxicating liquors.
And that procedural uniqueness is absolutely critical because it directly impacts how we interpret the amendment's pivotal Section 2. That provision prohibits the transportation or importation of intoxicating liquors into any state for delivery or use therein in violation of the laws thereof. It's an explicit textual grant of power to the states.
Highly unusual provision gives states a near-absolute, exclusive authority over alcohol regulation. Does it fundamentally elevate their police power above normal federal constraints? I'll be arguing that Section 2 provides a broad, unique, and, maximalist grant of state power that overrides standard Commerce Clause concerns.
And I'll argue that while the 21st Amendment certainly restored significant state authority to regulate the liquor traffic, that power is fundamentally constrained by the broader constitutional scheme of federalism. Modern judicial interpretation confirms that Section 2 doesn't license economic discrimination and must adhere to basic non-discrimination principles, particularly those derived from the Commerce Clause.
My position, it's founded on the recognition that the 21st Amendment represents the only express grant of power to the states found anywhere in the Constitution. This wasn't just some minor adjustment. It was a fundamental restructuring of the constitutional order specific to intoxicating liquors. This extraordinary authority was deemed necessary because of the inherent social problems, the crime, the lawlessness, the social decay that the unrestricted liquor business posed, especially following the widespread failure of federal prohibition. This necessity gives states a police power of far greater scope than what's directed toward ordinary business activity. States may absolutely prohibit manufacture, sale, or possession, or they may permit these activities under conditions prescribed by their legislatures. This power is something more than ordinary state authority over public health, welfare, and morals. Early Supreme Court interpretation really respected this broad sweep, holding that if a state could prohibit all imports, it logically had the power to impose lesser forms of regulation or even discriminatory taxation on imported beverages.
That historical reading, while yes, it reflects the initial judicial approach, it simply cannot stand against the development of constitutional law over the last 80 years or so. The primary goal of the 21st Amendment, I would argue, was restoration, not supremacy. It was intended to restore the state's pre-prohibition authority to maintain an effective and uniform system for controlling liquor traffic, especially regarding public health and safety. It was not intended, I believe, to authorize state-sponsored economic protectionism, which fundamentally undermines the concept of a unified national market.
You mentioned Commerce Clause concerns, but the 21st Amendment's text explicitly addresses the transportation of liquor in a way that the Commerce Clause doesn't address ordinary goods. Nonetheless, I acknowledge that modern jurisprudence has, attempted to integrate this unique grant of power into the system of federalism. My point is that the initial, robust interpretation, the one we saw in cases like State Board of Equalization v. Young's Market Co. back in 1936, correctly identified that Section 2 created a necessary constitutional exception to the general operation of the Commerce Clause.
Okay, I agree that it created an exception to what we call the Dormant Commerce Clause, that implicit rule that bars states from passing legislation discriminating against or unduly burdening interstate commerce. However, modern court cases have been extremely clear. That exception is narrow. It only shields non-discriminatory regulations designed to promote legitimate local public purposes like health, safety, or temperance. It does not allow states to discriminate in favor of local producers or in-state economic interests. When we look at cases like Granholm v. Heald and later Tennessee Wine, the courts struck down discriminatory schemes precisely because they represented, a straightforward attempt to discriminate in favor of local producers, not a genuine attempt to protect the community.
Okay, let's dig into that historical shift then, because it really represents the core tension here. The early cases, like Young's Market, explicitly stated that without the 21st Amendment, imposing certain fees or requirements on imported beer would have been unconstitutional. That original view clearly prioritized state sovereignty over the liquor product itself. But you're arguing that Granholm and Tennessee Wine mark a decisive break from that original understanding, right?
I'd say they mark a correction, not just a break. The Supreme Court in Granholm in 2005 explicitly criticized those broad interpretations that followed the repeal of prohibition. They stressed that the amendment's historical context shows its aim was to allow states to control the sale and use of liquor within their borders, allowing them to regulate the three-tier system, for example, but it did not give them the authority to enact non-uniform laws simply to discriminate against out-of-state producers.
So the court essentially decided that the principle of a national economic union, which is implicit in the Commerce Clause, somehow superseded the maximalist reading of Section 2's text.
Yes, exactly. And Tennessee Wine in 2019 reinforced this by clarifying that the Constitution prohibits state discrimination against all out-of-state economic interests. The argument that states can impose any regulation they wish on imports because they have the right to prohibit them entirely, the greater power includes the lesser power argument, that's precisely what the modern court rejected as inconsistent with the underlying purpose of the amendment.
But this takes us directly to the line between legitimate regulation and mere protectionism, a line which I think the courts are blurring unnecessarily. You argue that discrimination is okay if it promotes a legitimate local purpose. But my argument is that the regulation of alcohol is inherently about controlling who distributes a product deemed a social menace. The state has a fundamental right to control the market structure itself to promote sobriety and public order. For instance, states have adopted the complex regulatory framework known as the three-tier system: manufacturers, wholesalers, and retailers, which, as you noted, Granholm acknowledged states can mandate. This system is designed precisely to impose order, accountability, and tax collection within a potentially chaotic industry. When a state regulates who gets a license or where a product comes from, it is exercising its right to restrain, not merely protect local profits.
I appreciate the defense of the three-tier system, and you are absolutely right that the courts still permit states to mandate that system. Just for the listeners, the three-tier system separates the production, distribution, and retail sales functions, really to prevent the kinds of abuses that led to prohibition, like those old tied house arrangements. However, the courts draw a very clear line when the implementation of that system becomes discriminatory.
Okay.
For example, look at the residency requirements that were challenged in Tennessee Wine. The state required retail license applicants to reside in the state for 2 years, supposedly to ensure accountability and connection to the community. But the Supreme Court found that this requirement had, and I'm quoting here, at best a highly attenuated relationship to public health or safety. Its predominant effect was just economic protectionism, preventing qualified out-of-state retailers from entering the market. So if the state cannot demonstrate that the discriminatory practice serves a genuine, non-economic local purpose and that no reasonable, non-discriminatory alternative exists, the regulation has to fail.
That's an incredibly high burden of proof, though. It essentially renders Section 2 almost meaningless in any situation where the state wishes to regulate market entry or structure. If the historical and political context of the 21st Amendment, the absolute necessity of empowering states against the organized crime and chaos of prohibition, doesn't justify a differential approach to market control, why on earth did the framers go to the extreme length of using state conventions for ratification? This method was chosen specifically to empower states to deal with a profound social issue without interference from a national legislature that was perhaps still, beholden to the temperance lobby.
Well, I come at it from a slightly different way. While the unique ratification process certainly highlights the intent to grant significant power, it doesn't automatically translate into unlimited power. If the purpose was truly to make state powers supreme and completely unconstrained by the rest of the Constitution, why has the Supreme Court consistently ruled that the 21st Amendment does not license states to ignore their obligations under other constitutional provisions?
I'm sorry, but I just don't buy the idea that the power is so easily subordinate. What constitutional obligations are you suggesting are paramount here, overriding Section 2's text?
Well, take the First Amendment for starters.
In 44 Liquor Mart, Inc. v. Rhode Island, the court struck down state regulations that prohibited the advertising of retail liquor prices. They confirmed pretty clearly that a state cannot use the 21st Amendment to abridge freedom of speech protections. Furthermore, the 21st Amendment did not repeal the Supremacy Clause or the Import-Export Clause, limiting state power over international trade, as confirmed way back in Department of Revenue v. James B. Beam Distilling Co. The state power over liquor, although broad in its application to local health and welfare, is clearly subordinate to the greater constitutional framework. It's intended as a shield against federal interference in specific regulatory schemes, yes, but it's not a sword to strike down fundamental rights or, frankly, to engage in economic warfare against neighboring states.
I would counter that the tension you highlight is precisely the point of Section 2. The explicit text says importation is subject to the state's own laws. While I certainly concede that the courts have carved out exceptions for civil liberties like free speech, economic discrimination is a different animal altogether. Regulation of economic activity is absolutely central to the three-tier system. The power to regulate the age of purchasers, for instance, which was debated in South Dakota v. Dole, falls squarely within the powers reserved to the states by the 21st Amendment, as several justices powerfully argued in dissent in that very case. The control over who buys the product, where it is sold, and who sells it, it must be maximal to fulfill the public safety mandate.
But the majority in Dole did allow Congress to exert influence over the state drinking age using funding conditions, which shows that even on a core temperance issue, the 21st Amendment isn't some impenetrable barrier to federal influence, let alone to fundamental constitutional principles like non-discrimination. The narrow interpretation I maintain is necessary to preserve the economic union while still allowing states to adopt robust public health controls. We just need to ensure that Section 2 remains a shield for temperance and safety and doesn't just become a convenient cover for local economic protectionism.
All right, to summarize my position then, the 21st Amendment's unique history, including its ratification by state conventions, and the clear, unambiguous language of Section 2, fundamentally elevates the state's power to control intoxicating liquors beyond mere local police power. The historical context, the social demand for strict regulation and structure after the abject failure of prohibition, justifies maintaining this robust state authority against, I believe, an over-application of federal commerce standards. The states were given the right and the duty to enact such laws as they deem reasonable for the health and safety of their citizens, and that absolutely includes controlling who participates in the market and how the product is imported.
And my summary is this. While Section 2 certainly confirms state control over the distribution and use of alcohol, the modern constitutional trend, I think, correctly recognizes that this power is not absolute. The courts have appropriately limited state authority to prevent blatant economic protectionism, ensuring that alcohol regulation, like any other state action, must align with fundamental constitutional principles. This approach successfully allows states to implement strong public health and safety measures, such as the three-tier system we discussed, without authorizing harmful discrimination against out-of-state economic interests.
While this debate over the balance of power, it clearly remains highly active. It forces us to constantly reconcile the explicit, unique language of Section 2 with the enduring principles of American federalism and the necessity, as you point out, of a unified national economy.